Respected ma'am and dear participants, very good evening to all of you. I, Rishabh Raj, member of Legal Vidya, welcome you all to this advanced legal drafting course. So this marks your 22nd class of this course. So without any further ado, let's begin the class. Over to you, ma'am.
Good evening, Legal Vidya. Good evening, participants present over here. Wait for a second, we will start the session. So today's session, we will discuss about certain injunctions format. Formats, I think you have received already in the group. I have shared. We will start the class. Wait for a second, just. In the today's class, we will discuss about the temporary injunction, permanent injunction, and the mandatory injunction as per the schedule. So first of all, wait for a second, just sharing a draft, sharing a screen, I mean. Does the screen is visible to you all? I hope it is. Okay, fine. I will share all the three drafts of today's session, but first of all, we will go through some of the theory part also, because the format is just like it's just like the same thing with a little bit of the difference. But what is the temporary injunction? You must be acquainted with that first. So, a temporary injunction. There are two words here. First is temporary, and the second is injunction. So, injunction, and it's a part of a CPC only. First of all, you must be acquainted with this thing. So, injunction means what? Under the Civil Procedure Code, if there is any of the civil trial, then what happened? And injunction is a kind of a order which can be passed by the court against one or more of the parties to refrain from doing either or less commonly to do some specified act or number of acts. So, for example, if any of the person that is moving to the competent court for seeking an injunction order, then does the court grant all the claims of that person as granted by the court? No, not at all. Then, however, the process of granting an injunction is an alter to or to maintain the status quo, which completely depends upon the circumstances of the grievances there of that case. Okay. Now, the parties to the case can grant temporary, permanent, or mandatory any kind of injunctions. But, however, it is not a right of the parties, but injunction is kind of a remedy that can be granted by the competent court on the equitable principles, and the decision is discretionary one here. So now we will check out what is the injunction particularly under the specific relief act also, and there are certain procedures, there are certain aspects that are being covered under the CPC also. Primarily, before just moving ahead to what are the injunctions or what the injunctions means to say so, so injunction means an equitable remedy with a with where the judicial processes that compels the party to refrain all from doing or to do a particular act or a thing. If any of the person means any of the party here disobeys the order of the injunction that are being passed by the competent court, then there can be stiff monetary penalties and even imprisonment in the certain instances. The primary purpose we can say of granting the interim relief is the preservation of property in the dispute till legal rights and conflicting claims of the parties before the courts are adjudicated. Actually, the sessions is more about the sharing the drafts. That's why I am just putting the draft up on the screen. I'm not sharing anything, and because everyone is having the CPC Bear Act, so they can go with the section number 94 and section number 95 and the order number 39 also, that are particularly talking about the injunction. So I think there is no need to share here the provisions. That's why I just put on the draft. Now comes the kinds of injunction. There are certain kinds of injunction. For example, for different cases, there are different injunctions. So, ma'am, please share this draft in the group and more. Okay, I think the legal Vidya I forgot to share. You wait for a second. I'm just sending the graph to you all. Just wait. I don't know how they wait for a second. I think they forgot to share. I sent to them. Wait, wait. I changed the file name, that is 220. I was typing 22A. So please just change it to 220 now. Please, and don't get confused by the same. Anmol, please give a thumbs up if you receive the draft in the group. Okay, okay, Anmol. Okay. Yes, you can open the draft in your mobile also if possible. Yes, that's why I didn't just mention the theory part here. Okay, yes. So injunctions are very much very different in different kind of cases. For example, injunctions can also prohibit the future violation of a law. For example, trespass to the real property, infringement to the patent. These are the certain examples: infringement to the copyright, infringement to trademark, etc. But the competent court consider the duration and the stage and accordingly grant different type of injunctions. For example, our first injunction is the prohibitory injunction. Prohibitory injunction, first of all, we will take it with the example. Just imagine there are two parties, A and B. They are residing in the same society, and the B wanted to trespass premises unlawfully. Then A claimed before the competent court for the injunction to grant direct B that B shouldn't enter a premises. So telling not to do a certain kind of act is a prohibitory injunction. I hope you got the point. What is prohibitory injunction? Means that the competent court can also grant any kind of a prohibitory injunction to restrain or forbids a person from doing some act, or the order is passed that not to do any such act. Prohibitory injunction are also known as the restrictive injunctions and preventive injunctions also sometime. Now there is a mandatory injunction, very important, and we'll share that also today. Now that is what a mandatory injunction is. The competent court can grant the mandatory injunction to do some positive acts or to compel, commands, or order some persons to do something. Particularly SRA Act, there is a section number 39 also of the SRA. I think that is also important to mention here. That is a specific relief act 1963, if I'm not wrong. 19, and please just give a thumbs up if SRA is 1963. That is a section number 39, but it does not define, I think, categorically that dealing with the mandatory injunction, but there are two elements there in the mandatory injunction that is to be consideration. That is, there must be an obligation on the part of the defendant to perform the certain acts or the breach of the obligation which is particularly alleged by the plaintiff, or then there another element we can say under the specific relief act 1963 is a relief that must be enforceable by the court. Now you would say, ma'am, this is the law, and give us an example upon the same. Okay, anyone of you can give the example of the same. Just put in the chat box. Meanwhile, I am also telling you the example. For example, we will take the example of a tenancy. Okay. Now, A is a tenant without the permission of the landlord that has built a garden terrace, or okay. Then that is an addition to the rented house. According to the leave and license agreement, particularly, or the Rent Control Act, A has to take the prior permission of the landlord and to do whatever kind of activities, alterations, additions, and so on. Then what would happen? He may here. What is that the B may seek a mandatory injunction to just demolish the garden terrace with the which A has built without the permission of the landlord. So basically, what is here? It is like injunctions are sometimes can be stated as relief in the nature of a quite quasi ailment. That is means that a proper case mandatory injunctions can be granted. Matlab, we consider it's a threat to the infraction of the plaintiff's right before the infraction has actually occurred. Now there is another kind of injunction, that is a permanent or the perpetual injunction. Permanent or perpetual injunctions are like they are granted by the court only, but they restrain the party from forever doing the act complained of. But the perpetual injunctions or the permanent injunctions can be granted after the final hearing and the decree has been particularly passed. And now, uh, wait for a second. Now there are certain sections also of the SRA 1963, that is section number 38 to 42 particularly, that determines the rights and liabilities of the parties. Now we will take one more example of the same. For example, we will take again of the rented property. It's a rented property, like A has rented his flat to the B. Just wait a second. I think someone want to join the call. Just wait for a second. Okay, wait. Now we will take, sorry, it was someone who was about to enter in the class. Yes. Now we will take one of our example. One more example is again related to the tenant property. For example, A has rented his flat to the person B. Now who is a tenant? Now B has failed to pay the rent since 2 months. Now A may request the court to grant an injunction against the tenant continued use of the property and ask for the eviction from the A's property. This is a very basic examples of the same. Okay, now there is another injunction, that is a temporary injunction whose format is already displaying upon the screen. I will discuss the formats also in detail. That is the temporary injunction that is granted by the court when the defendant is about to make some of the injury to the property of the plaintiff, or the we can say that the defendant is making kind of a threats to the plaintiff to dispose the property or create a third party interest in the property. Then what would happen? What would be done in that situation? Then the court may grant a temporary injunction just to refrain to restrain, or not to refrain, but to, I think, restrain the defendant to do such act or make any other order to prevent the dispossession of the plaintiff or to prevent the causing of the injury to the plaintiff. So these are the things. Now the question comes in mind: who may apply for the temporary injunctions, and against whom the temporary injunctions can be issued? So there is a one order related to the same, that is the order number 39, rule number 1, where the any party of the suit can apply for the temporary injunction. Wait. Yes, so injunctions can be issued against any of the party and not against a stranger only or on the third party. There are certain basic principles also, we can say, when the injunctions are being exercised. That is, first of all, that must be the irreparable injury must be there. There must be the balance of inconvenience. There must be prima facie case. Prima facie means that there must be the some case that is support of the right that is being claimed for the plaintiff. So these are the certain facts you must know before we jump into the injunctions. I hope you got the basic concept of the injunctions. If you got the basic concepts of the injunction as per the law, then gives a thumbs up or either put yes in the chat box, and then we will directly jump into the formats for today's session. Because they're directly jumping into the formats is none of the relevancy. Yes. Now it's a first now uh, it's a first draft that is talking about the temporary injunction. Screen is visible to you all. If anyone meanwhile having any question regarding the same, then please ask. If there is no question, then we'll start the draft. Okay. I think no one have any question. Yes. So that this is a draft of the temporary injunction. Temporary injunctions are kind of a draft. When the drafting of the temporary injunction is required, then did you remember the draft of the plaint or the suit? Okay. So when you draft the plaint or when you draft the suit, then there are certain conditions. Now, same conditions are applicable here also. So yes, yes. So this is like in the play court of means whatever the court is the civil judge name of the judge, then civil suit number. It's already visible. It will be named as plaintiff versus the defendant details. Now we will mention it that there is an application for the interim injunction. Interim injunction means the temporary injunction here under the order number this and the order number, I mean 39, rule number 1 and the 2 of the CPC. Then what would happen? We will mention that what are the circumstances or the facts of the case, that the plaintiff has filed the suit. For example, purpose is recovery of the possession of the disputed property, or for the eviction of the tenant, and so on. There can be the any of the reason. The disputed property, the proper description must be there. Okay, now then what would mention that start with the chain of the events. For example, you don't need to mention these things that start with the chain of the events that has led to the filing of the present suit. Means that the subsequent subparas must be there, that must be just making the clear understanding of the events. Then would mention the chain of events that it will establish a prima facie case and the further investigation or the action is needed. As you already, I think, acquainted with that, I have mentioned that there must be the particular prima facie thing is that the chain of the events must be mentioned there. Then there is the irreparable damage that are being caused, so that also being mentioned there. So the reason that clearly states the balance of the favor in the plaintiff's side. For example, disputed property is there, because for most of the temporary injunctions are being issued for or exercised for the disputed land. Then the irreparable damage will be there. So the reasons that mental trauma is there, emotional hurt is there, financial loss is there, or that can't be compensated in the monetary terms, and all that must be mentioned. In the plaint also, we used to why we file the plaint, why we file the plaint in the court, to seek any kind of a relief now. Then we mentioned that what we have requested from the court in the form of a prayer. Same in the injunction application also, we will mention the same. It's just like the plaintiff therefore prays that the owner finds it fit to deliver a show cause notice to the opposite party, putting forward this reason why injunction shouldn't be granted. Pending hearing of such injunction petition, it is prayed that the interim injunction order is to be passed to restrain the defendant from causing any harm to the disputed property. Then it would be put forward by the signature, place, date, advocate, and that there is any schedule or any kind of a documents or any kind of a evidence that would be important to be just filed, then they must be there. Then it will be followed by the affidavit. So this is the basic draft of the temporary injunction. Actually, one thing you have to keep always in mind when you is just go through the civil drafting especially, then in the case of a civil drafting, the draft of all the application more or less are same only. The only thing is that when we discuss about the important aspect, let me tell you there also. Yes, this is point number 1 to 6. I think the point number 1 to 6 are visible to every student here. So point number 1 to 6 are the main important context or the body text. That is very important, that you how you are mentioning that body text, because that is very important, and that contains all the relevant facts of the meeting and so on. So that must be mentioned very carefully, unless more of the content is same or less. Okay, so this is the first draft. I hope you are acquainted with the draft. Once after the class it's over, you can just revise the draft, and it will be easy for you to just get acquainted with more and learn about the more. Can we jump to the another draft? If we are, you will understood the first draft. Okay, Shrishti. Okay, wait for a second. By the way, I have shared all the drafts in the class group just a second ago. Wait, the screen takes 1 to 2 minutes to share. The screen is visible to you all. Okay, so now this is a draft of the permanent injunction that is being the injunction is being granted, that the granted regarding restraining the defendant from dispossessing the plaintiff without following the process of law from a shop to let him in, and for mandatory injunction granting the defendant number this to restore and reconstruct the outer boundary wall and the gate of the height from the present. So in the what I have mentioned in the bold, what is in mentioned in the bold in the sample is just the hypothetical circumstance, hypothetical case. But the draft is started from the in the court of district judge. Suit number is this, and the plaintiff is this, and versus the defendant is this. Most respectfully show it. What is the being show it? Then we will mention about the text body or the case body. That the defendant number one is the father, defendant number two sons, and so on. Then they go look. Sorry, look from point number one to point number last, that is all talking about that what is the circumstance of the case. These circumstances from vary can vary from one case to another. So in the chronological order anyhow you have to mention. For example, thereafter on I have mentioned a lot more times. So thereafter this thing happened, thereafter this thing happened. In the point number 10 we have specifically mentioned the plaintiff contacted the defendant to redeem their assurance. Their tone was found to be aggressive. Their tone was found to be hostile, which causes apprehension in the mind of the plaintiff, and he is likely to be deprived of his lawful possession of the premises any moment. The plaintiff approached the local police for restoration of the boundary wall, so on. So these are the things that are need to be mentioned in the chronological order. That on that particular date, for example, point number 11 went to cover the check for this to clearance up to the up to that rent, then the things happened. So these are the till point number 15 we have mentioned about the chronological order of the events or the circumstances of the dispute or the things that was happened. Now prayer as such same as the plaint, that it's respectfully prayed with this honorable court to be pleased to grant a decree for the permanent injunction. And for the permanent injunction means that the from restraining the defendant from dispossessing the plaintiff's property otherwise that is not following the process of law, and so on. And there is also decree of mandatory injunction directing this any such relief the court may deem fit, think so, and the proper relief, then that would be signed placed through plaintiff, and the date would be mentioned through advocate. Verification will be done. Verification we also done in the case of the plaints also, and the written statements also. Here same, the verification is required. If the court officer asking you to submit the oath certificate or the affidavit, means that the affidavit, then you have to prepare the affidavit for the same. So anyhow somehow this is also the same, more or less like the plaint, right? The temporary injunction. Now we will jump into the third draft of the same. Are you getting to the draft? If anyone having any doubt or query, please put in the checkbox. Please feel free to ask me any kind of a query related to the CPC, related to any other law also. You can ask me any of the query if you people have. Bhakti is there, Labib is there, Prableen is there, and Vijay Pratap is there, showing on my screen. Anamika Sharma is there, showing on my screen. Akash is there, A. Soni is there. So these are the Chelsea Chopra, Bhavna Gupta. Are you getting now what I'm trying to tell you? And please, for the better understanding, okay, Kirtan, and for the better understanding, please go through the drafts once the class is over. Now we will share the third draft of the class. Wait for a second, just be in the class. I'm sharing the screen. Drafts are there in your class group also. You can take from there. These drafts are very important. Please always keep them with yourself. So when you go for the internship purposes or when you start litigation, then you can take the references from these drafts. These drafting is never been absolute. Drafting is like a craft work.
Hello, ma'am.
Law, yes.
Should we keep the hard copies of this draft with us? Are they important like for lifetime at any time?
Yes, you can get the print out of these copies and please keep with yourself. I do keep the hard copy and the soft copy both. Even I have every a
No, the
draft.
thing is like the sometimes the soft copies go here and there and hard copies stay with us at proper folder. So
Yes,
is it helpful?
yes. Yes, please get a spiral binding of all the drafts compiled at one place because you can take the reference now. I know every draft is not same. What are the circumstances can't be mentioned in the sample draft, but by the help of a sample, you can just take the reference. Okay, I have to mention this thing with this word. I have to mention prayer like this. I have to mention the verification like this. Date is there, place is there, name is there, plaintiff is there, so there are so many little bit things, technical things. It's better to keep with yourself, and it's for everyone who are present here, including me. 28 people are here. It's important for everyone just to keep the drafts. And you never know that once you are into the teaching also in future, and if you are into the teaching, then you will teach the clinical subjects also to the students. So that might be helpful there also. Yes, nothing is waste in law. It's either whatever in the past, either whatever in the future, in the present, nothing is waste. Okay, so please just keep with yourself. Yes. Now this is the last draft of the session, today's session. Yes, Ranvijay, yes, Kirtan. Okay, Kirtan, you can just put your thumbs down. Yes, anyone else have any question? Then please just feel free to ask me. I'm just here not to just, it's not a monologue session. It just, I'm here to just clear all your doubts regarding the clinical aspects of the law, and that's only the successful section will be if your all your doubts are clear. Okay, now yes, it's the third draft coming, jumping into the draft, that is the mandatory injunction. Okay, there is one question in your mind, but no one asked me, ma'am, what is the difference between all these injunctions? Temporary injunction is there, interim injunction is there, mandatory injunction is there, permanent injunction is there. Yes, anyone would like to, is there any difference between the same? Any one of you? Please don't search on the Google and so on. If you
Ma'am,
are
can you
doing so,
please repeat the question, please?
yes, what is the difference? Do you think there is any difference between all the drafts I'm sharing to you today about the injunction? It's a temporary injunction, mandatory injunction, permanent injunction. Is there any difference between all? Please do not Google if you are doing so.
It
Yes,
depends
ma'am.
according to the matter.
Hmm.
Yes, ma'am. It is different.
Hmm. Yes, I asked.
Yes, ma'am. It is completely different with each other.
Okay. You said it is completely different with each other. The word itself, the it word itself tells. Nagendra is there, Ayaz is there. Okay, it is different with each other. But how these are
The
different with each?
temporary injection is like during the time of the custodies and like during the time of the case is going on, and
Okay.
mandatory is like ma'am. Actually, I am telling my answer in on my own thinking. I am not like the
Please go ahead. No other
whole
issues.
correct.
Yes, please go
Yeah,
ahead.
so mandatory is like type the case has come to the final hearing time and now the case is going to be dissolved and like now
Hmm.
mandatory the thing is like it's coming so on that time the injection is used.
Hmm. Good.
It might be
Probably.
wrong, my answer might be wrong, but just
No.
according to
Your
me.
answer is right. Absolutely. Under the law, there is no as such differences between the all. It's all depends upon the circumstances. Yes, ma'am. Temporary injunctions means till the judgment is out. Okay. Till the judgment is out, there is no as such term in the law, probably, and the court puts hold on that action. Okay, so probably you tried a good attempt, but there is no as such thing. The judgment is out. First of all, it's like the court order something or the decree is passed. It's just like that, as per the law, na, if you use the legal language. So these are the lacunas, dear participants. You have to learn all these lacunas only, that what the term you have to pass. The judgment is not out at all, and these are very important things, and in the litigation these are only the things that hold the relevancy, that just make you the experienced advocate. So whenever you just start reading or go through the barracks as much as possible, no need to go through the commentaries on the very first site, no need to go through the textbooks on the very first site, just go through the barracks and everything. Or the most important thing in the barrack, the definition part. Definition part is just like a very important aspect that you have to be just acquainted with. Okay. Yes, I was asking about the differences. So differences is just like on the behalf of the circumstances, on the behalf of the stages of the suit, that at what stage the suit is being, at what stage your case is being in the court, then only the injunction is being granted. For example, your trial is being in the proceeding, the trial is being going on and you are seeking any temporary leave, then you can go for the interim or the temporary injunction. As allow like a mandatory injunction means that, for example, something to happen or something relief you are seeking, and for that there are some of the restrictions or some of the for example, we can say the action need required to be stopped, and that is very important. Then you have to go, you would go for that mandatory injunction. And the if you are looking for the some of the action that need to be stopped as soon as possible for the permanent relief, then it's a permanent injunction. In the CPC, there is no as such differences being mentioned there. And when you just dive into the pool of the litigation, then you will be acquainted with yourself by yourself. Okay. Yes. Now jumping into the mandatory injunction. Mandatory injunction, same as the draft. The draft will be started with which of the court you are addressing to, with which of the courts you are going to file the injunction application. Then it is like at the district judge Dwarka court. Okay, now the civil suit number is this in the matter for plaintiff and versus the defendant. The dates are there, event is there. For example, and the now the civil suit seeking a permanent prohibitory and the mandatory injunction against the defendant under the section number 37, section number 39 of the specific relief act. Most respectfully show, for example, you can also start drafting in the same way like the description of the parties, what the description is, who is the plaintiff, who is the defendant, then what's their relationship, a relation, is there any relationship. Then you can also mention that what are the certain facts that are being leading to the filing of the present suit or present injunction. So these are the same things that are being mentioned. What is the court fees you have paid, what is the value of the suit is there, what is the value for the jurisdiction is there, you have to mention. And you have to also mention like the suit is being filed in a bona fide manner. If you wish to, then you can also just you can also be just we can say mention these things like prima facie case, there is a chance of succeeding in the case, or there it's just like a convenience lies in the balance of convenience lies in the favor of the plaintiff, and so on. So these are the certain aspects that you need to mention. Now there are certain annexes annexed, and then that would be followed by the prayers of the same. Now the prayers must be like what are the reliefs you are seeking from the court. Okay, so the whatever the draft we are sharing are just like same as the drafts we have started with the plates. So simple, this is the same draft of the same. Now, yes, so these are all the injunctions: draft, mandatory, permanent, and the temporary or the interim. Yes, and now we will take all your queries. If anyone having any queries, or you get with the draft, the drop down also there some same things are being mentioned. But first of all, now if you want to excel in the civil litigation or the civil drafting, you can do one thing: start practicing drafting the plaint. First, you are acquainted with the plaint, then it will be easy for you only to draft any kind of application under the CPC. Yes, this anyone have any query regarding the same, or you get the drafts? 27 people are here, including me. No one is having any of the queries. How's your studies are going? I think your semesters will be fall in the month of December. Now only Diwali week is there, and after that all this just exams, periodicals, class tests. Exams on 2nd to 11th
Exams.
December.
Our exams were on 2nd December, but now it's postponed to like 25th January on University of Mumbai.
Okay. All the very best for your exams. In which semesters you people are studying, let me know. And for your exams, if anyone need any kind of assistance, then you can ping me. It's December second week, Akash, exams are there. Yes, I can understand. And the exams are just like a roller coaster rides or horrible rides for the students. Na? Not to panic at all. Just start preparing from now only. और अभी ये बात don't waste this weekend now because it's next week, it's Diwali. So just November 20, Praveen, you have the exam prepared hard. बच्चे all just revise the notes. Seniors are saying it's hard to get 65% in the Delhi University. Which senior is saying so? It's not hard to get the 65% in the Delhi University. Most important thing, whatever is being asked, you have to mention that only in the copy. If the concept is asking, then you have to mention the concept. If the application based questions are there, ma'am, I graduated this year only. Okay, congratulations, Ranvijay. 90 to 24 batch. All the very best for your future. And who are in the academics right now and going to give the semesters all the very best. My wishes are with you all. Okay, the Akash, you are saying that it's very hard to get the 60. No, not at all. In the DU, it's not hard to get. For all the students, it's very important to know. You must understand one thing. If the concept is being asked, then you have to answer the concept only, na. And if the application based questions are there, then you have to mention the law first, then the application you have to solve. Third semester exams are there, Sony. Very good. Jurisprudence is there. Okay. Start reading the jurisprudence. Anirudh Prasad Pranjape from now only. Environmental law. Okay. Your environmental law include which act? Water Act, Air Act, Environmental Protection Act, and which acts remaining? Land and Tenancy Act. So Land and Tenancy Act of which state, bache? And in labor law, which acts you are studying? Let me know. International law is a very easy law. In the international law, you have to go through 5 to 7 topics, and those are very easy topics. Just go through the case laws. In the labor law, which laws are you studying right now? Because in our university, the syllabus has been just changed for the labor law. So tell me that what are the Haryana and Punjab land laws. Okay, for the Haryana and Punjab land laws. Okay. And for the environmental law, I think you are also just go through the first semester. Okay, family contract, BNS taught, and the jurisprudence. Okay, jurisprudence is there. Family law, mein Hindu law is there. I think in your semester, Akash, or it's a comparative family law is there. A contract is very easy in your first semester, Akash. Just go through the Bear Act thoroughly go through the Bear Act. Tort is a non-codified law, uncodified law. So tort is very easy. You have to prepare 5 to 7 topics only in the tort. We'll take the classes of you all once the sessions of the drafting are over now. Then I will try to just make you acquainted with everything. It's very good to see that the young generations are now pursuing the law. In the Industrial Dispute Act is there, Trade Unions Factory Act is there. Okay, very easy subject. For the Industrial Dispute Act, you have to prepare 2 things particularly. First of all, in the Industrial Dispute Act, retrenchment is there and strike is there, and one more thing, that is the through the conciliation process, international Industrial Dispute Act. Anamika, is there any good book for the international law? Yes, Law of Sea Municipal International. It's a Kapoor book is there, na? SK Kapoor book. And H. Agarwal book is also there for the international law. Please go for the SK Kapoor book. That is, I think, green in cover, and I think 2022 is the latest edition. SK Kapoor book is there. So you can cover that from there only. And all the law students who are giving the semesters, now I will request all of you, please don't refer any kind of a question answer book or Dukki kind of a book. Please don't refer. It's my kind request to each and every student. I know marriage, divorce, maintenance of both Hindu and the Muslim law and family. Okay, comparative family law is there. So a very easy topic. Once again, you would be like, why I am saying very easy? Because I am acquainted with. No, not at all. But do one thing. Now start making your short notes, crisp notes from now only. Then it would be easy for you only to revise, because there nothing new should be read at the time of the exams. For the divorce, And for the maintenance, okay, maintenance you have to study, I think, both of the CRPC also and or the BNSS also. That might be little bit difficult for you, but marriages under the Hindu law and the Muslim laws were very easy, very easy. And please start making the crisp notes from the starting only, so that, and don't, please no need to refer any kind of a question answer books or the dookies. These are not good for the future. But once you pass the semesters, but I think your goal is not to pass the semester. Your goal is to just make the career, full-fledged career in the law now. So then start having the practice of reading and reading and reading. Just makes books your best friends. Wherever you go, start reading. Either read for 2 hours for thoughts or thought, and take the things like either for the 2 to 3 days you're gonna study the thoughts only. For the 2 to 3 days you're gonna study the contract only. For the 2 to 3 days you're gonna study the Hindu law only. And for the international law, go for the S.K. Kapoor, the best book, the wholesome book. You will find everything there. Municipal law, international law, and for the UN, United Nation, yes, you can go for the S.K. Kapoor book also, and one book of Pranjapay is also there if you could find in the library. And one more thing, you can go for the, if you anybody needs the notes now, you can go for the PG Pathshala syllabus also. They also provide the good notes. EPG Pathshala. I guess all the very best for your semesters. It's good to see that you people are just. How's your studies going, by the way? It's not good to ask at this time because
Ma'am,
all.
that EPG Pathshala has the
Yes.
all subject notes or certain specific subjects like CPC and CRPC or all subjects?
Mhm. But they have the notes of the research methodology, constitution, jurisprudence, family law, and which subject? These are the subjects there. Major subjects are available there. I think they have the notes of the contract also. Yes,
Okay, ma'am.
yes. Acha, okay. Anamika is asking, can you suggest an approach to tackle CLAT PG in the less time? Okay, so the only thing, the approach you can just go adopt for the CLAT PG is go through the Supreme Court latest judgments. Just please go through the latest judgment pieces, and that's the only key to succeed in the law. And first of all, now for the CLAT PG, now you have to do one thing. You have to just make the specific notes for each and every subject, and then refer to the case laws, latest case laws of the high courts and the Supreme Courts and their judgment pieces. Just and you can do one more thing. I think everyone must have visited the SCC online on the daily basis on a then go then on the SCC online blog website. There is a one column that is OPED is there. So there some of the writers and the authors are just daily posting about the certain Supreme Court cases. So please make a habit, anyone of you who are preparing for the CLAT PG, please start visiting. And the Manupatra on the LinkedIn, I think every student over here is on the LinkedIn. So Manupatra on the regular basis is publishing PDFs regarding the latest Supreme Court judgments. Please go through those judgments, and that is the only key. Because when I approached the CLAT PG in the 22 also and in the 21 also, I just approached the same. So please go through the Manupatra in the very less time, and just keep an eye on the SCC online blogs website. That will help you a lot. Means a lot. Yes. Anyone wants to ask anything? It's a good to hear that you people are just want to go far in the law. Kudos, man. More power to you all. All the very best for your future. May you just excel in the law career. Because only passing the semester is not the goal now. You have to just excel, make the full-fledged career in the law. Yes, absolutely. I wish everyone a very lots of luck. So I think we should wrap the session. If anyone have any query, then please ask, or else tomorrow we'll take the class for sure. Is there any other website also where I can refer the latest judgment? Yes, you can watch the paid websites. They are very high fees. ESCR, yes, ESCR is there. And and one more thing, that I have the mail subscription. Wait for a second, I'm just checking the mail. I have subscribed to the mailing list of Supreme Court judgments is there, na name is there. Wait. I'm just telling you. Acha, okay, one more thing you can do is just watch the YouTube channel of the Live Law. I think Live Law, everyone is acquainted with Live Law. Please watch that short videos or the 5 to 7 minutes videos of the YouTube channel. Subscribe to the WhatsApp groups of the Live Law or the Bar and Bench. You might be. Supreme Court Observer is there. Just subscribe to their mailing list and they will send you the detail they send you weekly details. A very good website, Supreme Court Observer. Yes, Sony, yes. They asked for the high fees, I understand. ESCR is also there. Good thing, just for the free authentic judgments, yes. Supreme Court Observer is there, SC Observer. You can go to subscribe their mailing list. Live Law YouTube channel is good going nowadays. They are very regular. They are posting the videos on the daily basis, either the short videos or the latest updates in the High Court, in the Supreme Courts, and they also just publishing the videos of the Supreme Court judgments or the High Court leading judgments. And just please subscribe to the WhatsApp group of Live Law also. And Manupatra, for the Manupatra, no need to take any such subscription. They are also publishing on the LinkedIn. On the randomly they are publishing the PDFs. You can refer that also. Okay. And if I will find anything useful for you, then we'll like to definitely share to you all. I will share. Something is important for you all. Yes, I will share. Once the session is over, I will start sharing each and everything that is very important for you all. So I hope many of your doubts are being cleared. And yeah, Anamika, no need for the thank you. Anytime, anything for you all, dear students, participants. Yes, anytime. It's my duty now because I'm teaching the lot. So it's my duty just to make acquainted everything to the law students. It's my duty. Yes, because you are the newbies now. That's why. Okay. Yes, so I would request the legal Vidya to wrap the session, or if they are not here, then it's a end of the today's session. We will meet in the tomorrow session for sure, and with a new draft, with a new topic, and we'll try to sort any of your queries. So good night everyone. अपनी सेहत का ध्यान रखिए, हेल्थ का ध्यान रखिए. वेदर चेंज हो रहा है. हैप्पी लर्निंग, हैप्पी रीडिंग. बहुत पढ़िए, बेयरक को रेफर करिए, बेयरक की रीडिंग करिए, बार कीजिए. ओके, विल मीट यू टुमारो इन अ न्यू सेशन. गुड नाइट, टेक केयर, हैप्पी लर्निंग.
Thank you so much, ma'am. Thank you so much, participants. Now we can wind up this session. Good night, everyone. Take care.
Thank you, Prabli. Thank you, Ranvijay. Thank you, Anamika.